Hello, YouTube. I'm Vince White. I'm an employment attorney who is improperly lit. Perhaps that's better. And we are answering publicly posted questions from YouTube users today. We have a question from YouTube user Almost There, which I believe was posted about 10 hours ago. And it was posted on our video entitled, "What does similarly situated mean in the context of workplace discrimination claims?" Almost There asks, "Really enjoying your channel. Thank you. I hope it's useful. What if your former employer admits in their position statement, literally, that an employee told HR about a disability and also shares easily discoverable lies in their position statement? The employer did not use an attorney. Can they change their position statement?" Okay, so I have a couple of videos on this channel. First and foremost, great. I'm really glad they admitted things that help you. They're lies. Start a list. Lies are opportunities. Lies are really valuable in this industry. You want to keep a list of all your employer's lies. You will forget their lies, often because their lies will be so voluminous that you can't keep track of them all. So keep a list. Keep a list. In that list, mark the page and the document and the date that lie came in, right? Because sometimes this is a method of version control, right? If your employer's amending their position statement, they could amend it 2-3 times. It's rare, but it happens. So you might go to the position statement one day and be like, "I can't find the page number for the lie that I marked down for myself." Well, it's because you're looking at version 3 of the position statement, not version 1, okay? Remember, the heart of an employment attorney is irrational aggression and detail-oriented behaviors. Which, yeah, those things don't go together. But here we are. That's what we need. That's what's going to carry the day. So keep a list of all the lies. Keep a list of the date the lies that came in, what version of the document they came in, and the page, and if you can, the paragraph number. It'd be really handy for you, right? Save you big time when doing your rebuttal, but also when prepping for hearing. Okay, so I have a lot of videos on the channel about treating lies as opportunities. You should watch those. I'm not going to link them down below. Maybe Victoria will. She's much smarter than I am. And fundamentally, I'm lazy and I don't like searching through videos to link you to things when I know you could search the channel. But yes, they can change their position statement. They can amend. Often the employer will be granted leave to amend by the investigator. It's not guaranteed that they can, but 9 times out of 10, the investigator will be like, "Yeah, sure." Now, that's important, right? If they amend, don't get rid of their first position statement that's chock full of lies. You will need that later. It's very likely that no one will give you a copy of the original position statement later on. And you will need it. You may need it come federal trial, you may need it come agency hearing, you may need it in arbitration. But it will be useful for you to demonstrate the lack of credibility your employer portrayed in their first position statement when they were not represented by counsel, right? It is very likely your employer will eventually be represented by counsel. Often, they realize they're in a lot of trouble and they go pay for expensive counsel. And expensive counsel is tough to beat sometimes. So, you want to be fully stocked with things like proof of when the employer didn't have counsel and wrote 10 pages of lies. Yeah, did you write this thing? Hypothetically, we have this employer on the stand, right? The owner of the business. Owner of the business comes in, says a couple of things that are great for the employer's case, right? Great. So, employer, did you write the original position statement? I did, yes. Got it. On this page, did you say this? No, I think that we said it differently in the position statement. No, I think you said it differently perhaps in the second version of the position statement. Did you say this in the first version of the position statement? I don't know. Well, you can refresh the recollection. You can put it in front of them and say, "Why don't you look at the first version of the position statement?" Keep it in front of you. We're going to be looking at that a couple times today. Yeah, probably like 10 times. Yeah. Paragraph 16. Can you read that for us? Yeah, thanks. Thank you for reading that. Was that true? I noticed that's not what you said in your second position statement. Was your statement in paragraph 16 of the first position statement, was that true? Oh, it wasn't, huh? Great. Let's go to paragraph 20. I think listen, that's not really how you're going to do that. Like, I obviously testified in the record a little bit there. It was not good form. I'm rushing because this video is already 5 minutes long, and I want to give you a quick idea of what generally that could be used for. Is it necessarily going to carry the day for your claims? No. Is it going to be really, really useful for attacking credibility? Yeah. And I think it's always really important to remember that judges do this every day. Arbitrators, an administrative law judge who hears nothing but employment claims, or an employment arbitrator. I work as an employment arbitrator sometimes. I'll tell you right now, we hear the same stuff over and over and over again, and I get real excited to hear what someone lied about and why. And I have lots of ideas when I hear what someone lied about as to why they might have lied about those things, right? Oh, you thought this was bad for you? So you had to lie about it. Why did you think it was bad for you? Because you did bad things? You're a bad person? Yeah. Right? There's some value in looking at what someone lies about. And if you can, why they lie about it. That's at the heart of the process of finding the truth, right? And the truth, because you are an honest plaintiff, is your friend. Best thing you can possibly do is tell the truth. Easiest job in the world is to tell the truth. Even when you're under heavy attack from defense attorneys, if you're telling the truth, you're probably going to carry the day. So, long story short, YouTube views are almost there. I'm excited for you. I'm excited this is going well. I hope you find counsel, and I hope that you get paid very much. Good luck. Oh, if this was helpful, if my hair didn't bother you sufficiently that you want to go running and screaming, like and subscribe. It helps me to help more people just like you. Take care.